Today, let's talk about the Arbitration and Mediation Act of 2023, which repealed the Arbitration and Conciliation Act of 2004. This act acts as a unified legal framework for the practice of arbitration and mediation in the Federal Republic of Nigeria. A look at this act shows that it concerns itself with two different areas of alternative dispute resolution, which includes the practice of arbitration, and it has provided for the appointment of arbitrators and how many persons that can constitute an arbitration tribunal, the challenge of an arbitration or an arbitrator, the grounds that the parties have to exercise such rights of challenge, the cost, who bears the cost of the arbitration process, whether death or a change in status has any effect on the arbitral award. While the second part talks about mediation, what mediation is, who can act as a mediator, the number of persons, the qualities, and so on and so forth. Now, the preamble of this act has shown that it is a unified legal framework that will give guidance to the practice of arbitration and mediation in the Federal Republic of Nigeria. And it also gives recognition for the recognition and enforcement of foreign arbitral awards because of the New York Convention, which Nigeria is also a contracting party or state to. The objectives of this act and its applicability is also discussed under section 1 of this act, which means the purpose for the formulation or establishment or bringing into force of this act is all outlined under section 1 of this act, which includes 1, fairness in the resolution of commercial disputes between people, between states, between parties. Doing this by an impartial arbitral tribunal, and they must also ensure that there is no room for any form of unnecessary expense or delay. Looking at the traditional dispute settlement process, which is litigation that is going to court, how long it takes. This act has come into place to ensure that such delay is done away with, that parties do not have to go through lengthy period of attending court proceedings in order to get justice or redress for wrongs or damages that they suffer. So section 1 is talking about transparency, is talking about fairness, and talking about what? Taking away such burden of delay from the process of dispute resolution. Section 1 also talks about the parties not being forced, and also to note that the parties who have decided and chosen voluntarily to go through the process of arbitration will also be bound by the outcome of the arbitration process. That is, when the process is finally concluded, it means that the parties will be bound by the outcome, that is the award of the process of arbitration. It has also gone ahead to put responsibility on the shoulders of the court, the parties who are also in dispute, authorities who form or act as appointing bodies upon the arbitrator itself to ensure that there's expeditious resolution of commercial disputes. You don't have to accept on a matter and then you sit on it and time is going, because as time is going, the parties are running into a lot of costs. So this act frowns against delay, says there must be expeditious without any unnecessary delay or expense. So it is the duty of the court to do whatever that is necessary to ensure that that dispute is resolved. It is the duty of the parties not to inhibit. It is the duty of the party to do what is necessary. You cannot withhold information that is going to move the process forward. You cannot also interrupt the arbitration process. The act is very clear on this one. There must be expeditious delivery of justice when it comes to arbitration under this act. Now, its applicability includes and covers international commercial disputes by reason of the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention, which Nigeria is also a contracting party. It also covers interstate commercial disputes as well as all forms of commercial disputes within the territory of the Federal Republic of Nigeria. And any form of international or commercial dispute that involves Nigeria and any other contracting state. This is what forms as a guide, a unified guide. So whatever you are practicing in arbitration, it must fall under the provisions of this act. I hope you have learned something today. And not only that, parties must choose who will arbitrate. It must be a voluntary decision by parties to do. And once they have done that, it is their duty to also know that they have to be bound by the outcome of the process. Have a good day. Like, share, subscribe, follow us for more of such legal tips that will keep you informed and guided. See you.